Namaskar. The Honorable Vice Chancellor of NLUJA Assam, Sri KVS Sharma ji, Dr. Gunojit Roy Chaudhary, the Registrar, the eminent and distinguished faculty members of this institution who are present here today, my most beloved students, both from the graduation as well as the post-graduation courses. A very warm good afternoon to all of you. We are still in the middle of festivities, so I would like to wish you all a very warm Diwali. I hope, despite some setbacks, unexpected setbacks, you still had a very peaceful and joyous Diwali. It's a great feeling for me to come back to Guwahati and more particularly to this institution with which I have been connected since at least last 10 years. Therefore, I thank the Honorable Vice Chancellor and the Registry, his team members, for extending the invitation to me to come here today and interact with you. The program mentions lecture by guest. I refuse to accept this categorization because I am not here to give any lecture. I think you all are already bored of hearing lectures every day in and out. Rather, I'll tell you why I am here. I am here to hear your voices, your questions, what you're thinking, what are your thoughts, ideas, worries, anxieties about the life ahead. And in the process, if I manage to answer some of your queries, I'll be very glad. So I would like these sessions to be more of interactive nature, where I'll welcome all of you to ask questions coming to your mind, which is a very important component of growth trajectory of every individual and more particularly a student in law. Having said that, since some time has been assigned for sharing my thoughts, although there is no subject as such, I will take this opportunity to briefly address you on two very important aspects of legal studies. At least I feel these two slightly disjointed but very strongly interconnected areas of legal studies requires special focus from all of you. So I will very briefly share my thoughts, why I feel so, and thereafter, if you are ready, we can get into some question, answer, some interaction. The first area which I always felt and even today I feel is very important for every student in law, regardless of whether after completing the degree courses one chooses to be a lawyer or a faculty member or join any service. It is very important to understand what our constitution really resolves to give to ourselves. I am sure in course of your curriculum, you must have gone through the constitution, you must have heard important law lectures on various relevant provisions of the Constitution of India, and You will be doing so more in the coming years. But what I wanted to highlight today is to tell you that, as you know, the Constitution of India is a masterpiece crafted by the framing fathers, which actually announces a collective aspiration of the country, particularly for the common people and the youth of this country. It is a vision document full of promises for a brighter future. It will be for us, each one of us, and more particularly those connected with the field of law, to unlock the potential of this document. That can be done only when we understand in its true sense some of the important provisions of the Constitution, which are contained in Part 3 of the Constitution. That is the fundamental rights. Now, regardless of whether one is in practice or one is discharging the job of a judge, judicial officer, good majority of cases that the constitutional courts deal with today are actually connected with only 2 or 3 articles of Part 3. The first is Article 14, which, as you all know, deals with the principles of equality and equal protection before law. Then you have the freedoms under Article 19, and then Article 21, life and liberty. According to me, these 3 articles, these 3 fundamental rights, when combined together, lays down the basic metrics, the fabric for this country to survive as one nation, move forward, and also to progress. So therefore, not only for the law students, for every individual, every member of the society, every citizen of this country, it is necessary to have some understanding of what these provisions actually mean and hold for the society beyond what appears from the basic texts. Apart from that, the founding father of the Constitution, the Constituent Assembly Chairman, Dr. B.R. Ambedkar had himself said that the fundamental right under Article 32, which is the right to constitutional remedy, that is the heart and soul of the Constitution. Because having given the fundamental rights, if you do not have a very strong and robust mechanism to enforce it, then it will be a meaningless exercise. Now, it is true that all fundamental rights are not absolute. You know that I am not getting into the literature of these legal provisions. That could be a subject matter of another discussion. What I am trying to say is, what in essence does this right to equality mean? And to what extent these principles can be expanded to meet the growing needs of the society is a work in progress, is constantly a work in progress. Every day in the court proceedings, when matters come in, depending on the facts, the arguments, the contours are being pushed from one limit to the other, thus proving that the Constitution of India is truly an organic document. It's a living document. I don't want to get technical today because this is not the occasion. Maybe we'll have something more lighter to discuss. But those who are students of law, you must have come across decisions of the Supreme Court which started with the case of A.K. Gopalan, 1950. If you have read this, if you have read the judgment, you will see that the interpretation of Article 19 and 21 given by the Supreme Court in that judgment was, in today's context, a rather constricted approach. It was a rather conservative approach, conservative interpretation of that provision. But slowly we have seen several decisions. The decision in the case of Maneka Gandhi's case, the interpretation was much broader. Then we had Keshavananda Bharati, Golapnath, many other judgments. In fact, this ADM Jabalpur case, which was recently overruled, I think K.S. Puttaswamy, is that judgment? So that is a landmark correction of an error where the Supreme Court has restored the dignity of Articles 19 and 21 by accepting the minority views expressed in the ADM Jabalpur. Then you have Shreya Singhals case where Section 66A has been struck down. And so by interpretations, the Supreme Court has expanded the scope of these provisions, these fundamental provisions, which have and are going to play a very important role in the future for realizing the goals of each individual member of the society in one form or other. What I am trying to emphasize is that apart from your law school books and regular classes, I invite you to do a lot of study, lot of introspection, analysis of various rulings, judgments involving Articles 14, 19 and 21, so that you have a very clear understanding of what these provisions actually promises to the citizen of this country. This single line, freedom of life and liberty, it's a huge concept. It's a huge concept, and notwithstanding whatever work has been done involving these provisions, I personally feel there is a room, there is scope to do a lot more. And it is for young law students like you who will have to rise and contribute so that the courts can enunciate this law, further unfold it and make it even more citizen friendly and citizen centric. Now, having said this much, I want to now switch to another topic which I feel is extremely relevant. It's knocking in the door, and particularly for the law students, it's going to have a huge impact. That is on the issue of intersectionality between law and technology. You know, many of you must have heard it. Those who are a little older in the system have definitely heard it. When you talk about judiciary, the common criticism has been that pendency of cases, backlog of cases, and sooner or later when you start your professional life in whatever capacity, these are expressions you will also hear. Now, according to me, yes, it is true. This is the biggest problem. Backlog, pendency. But the root cause of this problem, according to me, and I am saying this for some other reason, which I will come to in next 2-3 minutes, we have not been able to address the issue of scalability of the judicial apparatus in our country. Now, when I say scalability, in very simple words, I'll try to explain what I mean. Scalability is the ability of a system to deliver with same efficiency, same accuracy, even if the numbers go up by manyfold. So, for example, we had a court system in our country immediately after independence, after the constitution was adopted, which was equipped to say handle 1,000 cases. Say there were 100 courts meant to handle 1,000 cases. Suddenly, because of various reasons, including maybe the economic liberalization in this country, the advent of various legislations, various new areas where legal actions were available and permissible, the 1,000 became 1 lakh, but the 100 court has remained 200, not beyond that. So there is an immediate fallout of scalability. So if 1,000 had become 1 lakh and 100 had become 1,000, then maybe the equation would have been more or less balanced. And thereon, we started losing the scalability factor of the system, which according to me is largely responsible for the backlog, the choking of the courts, traditional court systems today. And it appears that there is no solution in sight in near future. At least I have not heard anyone coming up with a foolproof solution. That solution, according to me, is available only when technology is embraced by the system in a much bigger manner. That's why I say that the root cause, according to me, is failure to address issues of scalability, and the only way it can be addressed, according to me, is by harnessing and embracing technology in the right places in the right manner, so that the efficiency of the system, the efficacy of the system, all are not only restored but remain intact and measures up to the public expectation. Now, you know, artificial intelligence is a term everybody is familiar with. What is it doing? It is, with the help of trained model data, trained on data sets, relevant data sets, artificial intelligence is able to create a pattern of decision making based on whatever data is fed to it, whatever data it is trained on, whatever precedents are available, and so on and so forth. Now, what are we doing as law students? Whether as a lawyer or as a judge, we are doing the same thing. We are trying to fit whatever data comes our way. We are trying to look up the precedents that are available, and we are trying to follow patterns and come up with an acceptable solution which we can offer to, if it is a litigation, to the court, and try and persuade the judge to accept it. Now, this same work which human mind can do, the cognitive ability of the AI system is thousands and thousands times faster than human mind. So, AI is bound to come to law. It has started coming to law, and there is no escape from this. The difficulty is, till today in our country, we do not have a clear policy guideline, a proper legislative framework, a data usage policy indicating to what extent data and metadata for that factor can be accepted and utilized officially for doing judicial work. But despite that, there is a lot of AI which is now into play in the private realm, in the private platforms who are using this AI and blockchain technology to do a lot of legal work. And I can tell you, very soon you will yourselves find in the middle of these technological advance, even as a law student. I can give you an example of something called a smart contract. Perhaps all of you have heard about what is a smart contract. A smart contract is a contract which is driven by AI, which is a self-executing contract. The contract is entered between two entities. When it reaches a particular threshold, I'm being very simple in my effort to explain it to you, the contract will execute itself. And in that process, there could be a dispute. Now, this entire thing is embedded in technology, but the Indian Contract Act accepts a contract which is based on the principle of consensus ad idem. Now, when two machines trigger of a contract, and in the process of execution, if there is a dispute, under which law will you adjudicate? Will you get into that dispute? If you come under Indian Contract Act, the first question will be, there was no consensus ad idem between two human beings to that extent. Maybe by agreeing to be a part of this smart contract, certain things were agreed. But later on, it is the technology which is taking the decision. The next example I want to give you is about something called IDSS. How many of you have heard this term before? Intelligent Decision Support System. Anybody has heard this? Then I'll try to be very, very non-technical, because otherwise you will start getting bored. Intelligent Decision Support System is now a part of the legal practice, partly in India but very much outside the country. When a decision is to be taken, there is a machine protocol through, I don't want to use technical jargons, you will get bored, but through the machine learning process, which gives you all the assistive support so as to let you arrive at the correct decision. And this is now a recognized protocol in the realm of legal studies, dispute resolution. Rather, it is being used in something called ODR, online dispute resolution, which is the online version of ADR, alternative dispute resolution. Then there is something called Contract Lifecycle Management. Now, don't be scared, because you must not have heard these terms, but I am telling you a little bit about this because I want to tell you something at the end. Unless I tell you a little about this, you will not be able to understand why and what am I actually trying to say. So a contract lifecycle management is again a AI and blockchain technology based technology which constantly monitors a contract. You know what is a contract? Two entities can enter into a contract containing certain terms and conditions, and if there is a violation, breach of the contract, then an action will lie. One of the parties, aggrieved party, would have the right to approach the court seeking damages for violation or breach of contract, etc. Now, what CLM does is, it allows technology to correct course in the contract. The machine will detect, okay, while executing this contract, we are heading towards a direction where there will be a dispute. So the contract itself changes its course. There is a turnaround period which is much shorter, and it can modify some of its clauses and take a different direction. If it sees that there is a risk in executing the contract in a direction, it can turn around. And that is also part of an agreed protocol between the two contracting parties. Now I know this is getting a little technical, I don't want to bore you with ultra technical stuff. There is a lot to talk on these things, but today is not the right time, maybe some other day we can discuss. And the fourth I'll tell you is issues coming out of generative AI. You have all heard about it. Generative AI, with this today, artificial intelligence is creating contents, pictures, and codes, and what else you can think of. These are called assets. Till the other day we thought asset is only a property, a car, a piece of gold jewelry kept in the bank lockers, cash. But today, bulk of litigation in the Western world is happening on digital assets. These are digital assets. These assets are locked in technology. You can't even see it. Something like cryptocurrency, which doesn't have any recognition in India as on date, and that is because our laws do not recognize cryptocurrency. But tomorrow, if it does, you may have as many litigations involving cryptocurrency as you have with normal money, money. Now, these are heavily embedded on technology, and if a dispute goes to the courts will not only have to adjudicate the dispute on the ambit of the legal framework of that country, but may even have to go into the efficacy, authenticity of the process through which it was generated. So just imagine how complicated issues can get. Till the other day I thought, okay, as lawyers, if you know a little that this is what AI is, this is how it works, that's good enough. But today I won't say that. The moment digital assets become an area of dispute in this country, the lawyers and the judges and judicial officers will have to go into the process. What process was used to generate this AI? For example, if there is a copyright dispute between two pictures generated by AI, for all you know, the legal battle can boil down into whether the same generative process was used to generate both these documents. And to that extent, the court, the judges, the lawyers will have to go into these aspects of the matter. So I think technology will have a transformational impact on law. Every aspect of law, it will have a transformational impact. I am being a little extravagant, I understand, but young law students who are in the cusp of joining the profession, if they are not well equipped with the understanding of technology, some expertise in the technological field, it may be very difficult to progress further. It's almost like 30 years back, I'm using an anecdote. We were used to driving vehicles in roads which are full of potholes, narrow roads. The vehicle speed was 45 km to 60 km per hour, and we were used to that. Today we have 8-lane express highways. You can't drive in the old fashion in those 8-lane express highways. If you try to drive at 60 kilometers, you will be rammed and dashed and thrown out of the highway. Now 140 kilometers is the new normal. So it's the same driver, it's the same driving skill, but a lot of change in the approach, in understanding the situation where you are operating. So that is why when I was interacting with the Honorable VC Saab, I was asking, do you have any course where there is an intersectionality between law and technology in NLU? He told me it is not there, and why it is not there, which is nothing to do with him. He told me that the university is very keen to have it. I feel these courses you should have had yesterday. Today is also too late. I don't know what will happen tomorrow. Because every day things are changing at such rapid pace that where will you start? Where are you going to start from? Today IIT Kharagpur is offering law. It's a purely technical institution. You will have to deal with issues like algorithmic biases, because technology in law means it will be an algorithm driven justice system. So one has to have clear understanding of how algorithms behave, how these mounted on technological platforms, what are their characteristics, and this will all seem very daunting if you are not initiated into the process in a very systematic manner, because we are lawyers, we are not supposed to be technicians or technologists, but we cannot do away from learning a little bit of technology, otherwise many of us may not remain relevant at all. So I want dear students to think about this, and even if immediately a course is not available, at your individual levels also, please see what are the options available, equip yourself a little bit. You have to have an idea of what is the challenge lying ahead of you. That you will have to have, because you will have to stay relevant. I will conclude with a short story to express what I mean. There was a time when a trainer of a mountaineering institution was sitting with his people who were getting ready to climb up a mountain. They were all training very hard because it was a big mountain. And the trainer guru asked each of them, now that you are about to climb this mountain, tell me, what according to you is the most important part of this mission? Somebody said it is endurance. Someone said it's preparation. Somebody said it's concentration. Someone else said it is training. So after some time, the guru said, you are all right, correct, but only partially correct. The biggest challenge is the mountain itself. Because if the mountain was not there, you don't need all this training, you don't need all this equipment, you don't need this endurance. You need all these things to be a while, because the mountain is standing before us. You want to climb that mountain. So you must know the mountain first. If you don't know the mountain, no amount of training, no amount of equipment, endurance is going to help you. So the students said, yes, we realize it. You must know the mountain before you. But in the process of knowing the mountain, please do not stop enjoying life as a law student or a legal professional. There is a lot of life to be led. These things will come, you will see it in the public domain. This will cause anxieties in your mind. How am I going to deal with it? Am I going to be out of work? Nothing of that sort. As the time passes, times will throw up challenges, and time will also give you solution. You will find your solution. All you need to be is alert, keep your eyes open, and whenever you feel there is a need to upskill yourself, please do it. Technology and law cannot be divorced. These are going to be hand in hand in the times ahead. And finally, my advice to the young law students, do not target money when you enter your professional life. Those who have done it, they have regretted. If you do work which is satisfying, which is in the core area of the discipline where you have entered, money is bound to come. Maybe it will take a little time, But those who have gone for quick money, which is now available for law graduates, almost all of them have repented after a few years into the system. I thank you very much. I thank Dr. Nandrani for giving such a wonderful introduction of myself. I once again thank the Honorable Vice Chancellor for inviting me. It's been a pleasure coming to you and getting an opportunity to address you. This has been a vibrant institution and I pray to God that it will remain so. God bless NLU Guwahati, NLUJA. Please feel free to ask questions if you have anything. I will be more than glad to answer. Thank you so much.